Module 3, Adjudication. Organized crime. Organized crime is a term used to describe a group of criminals who work together to commit crimes. Organized crime groups are often hierarchical, with a transparent chain of command. They may also monopolize criminal activities, such as drug trafficking or prostitution. Organized crime is a global problem. Organized crime groups are estimated to generate billions of dollars in illegal profits yearly. Those profits can fund other criminal activities, such as terrorism or political corruption. Despite the reputation to the contrary, studies show that today Italians are not actually strongly represented in organized crime. In the past, Italian organized crime groups, such as the Sicilian Mafia, were powerful. However, they have been weakened by law enforcement efforts and by internal politics. Other ethnic groups, such as Russians, African Americans, Hispanics, and others, are also strongly represented in organized crime today. These groups are involved in various criminal activities, including drug trafficking, prostitution, and gambling. Including drug trafficking groups, in fact, less than about 10% of organized crime groups in the United States would identify as Italian. Judges' views on crime. A judge's worldview is a set of attitudes and ideologies that influence how they see the world and make decisions. These attitudes and ideologies can be shaped by various factors, including the judge's upbringing, education, and professional experience. A judge's worldview can influence their decisions in many ways. For example, a judge who believes in the importance of rehabilitation may be more likely to sentence a convicted criminal to probation instead of prison. A judge who believes in the importance of individual rights may be more likely to rule in favor of a defendant. Defenses. In criminal justice, a defense is a set of arguments used to argue that the defendant is not guilty of the crime that they've been charged with. There are many different types of defenses, but some of the most common include 1. Innocence. This is the most basic defense, and it simply argues the defendant did not commit the crime. 2. Insanity. The defendant argues that he or she was not mentally competent at the time of the crime, and so therefore should not be held responsible for their actions. 3. Self-defense. This defense argues that the defendant was justified in using force to defend themselves, or someone else, from harm. Self-defense is not considered an excuse, but rather a defense. 4. Entrapment. This defense argues that the defendant was tricked or coerced into committing a crime by law enforcement. 5. Mistake of fact. This defense argues that the defendant did not know that his or her actions were illegal. And number 6. Necessity. This is where the defense argues that the defendant committed the crime because they had no choice. They were trying to prevent a greater evil. The type of defense often depends on the case's specific circumstances and the crime alleged. For example, in a murder case, self-defense or insanity might be a popular defense. If the defendant is accused of theft, they may argue mistake of fact or necessity. Deterrent effect. The deterrent effect is the idea that the threat of punishment can discourage people from committing crimes. There are two main types of deterrence: specific deterrence and general deterrence. The deterrent effect is defined as the assumed ability of the threat of criminal sanctions to discourage the crime before it occurs. Specific deterrence is the idea that if a person is punished for a crime, they will be less likely to commit that crime again. They'll remember the punishment and will not want to experience it again. General deterrence is the idea that if people see that others are punished for crimes, they will be less likely to commit those crimes themselves because they don't want to be punished. The deterrent effect is a controversial topic in criminology. Some people believe that it's a very effective way to reduce crime, while others believe it's not as effective. Frivolous lawsuits. While not strictly part of the criminal justice system, frivolous lawsuits are often used to try to legally extort money or harass people. A frivolous lawsuit is a lawsuit that's filed without any merit or basis in law. Frivolous lawsuits can waste the court's time and resources and can be used to harass or intimidate people. Frivolous lawsuits have spurred an increase in litigation. Several factors make a lawsuit frivolous. They include: the lawsuit is not based on a claim in law. The lawsuit is filed improperly to harass or intimidate the defendant. The lawsuit is filed without any evidence to support the claim, or the lawsuit is filed in a court that does not have jurisdiction to hear the case. There are several reasons people might file frivolous lawsuits. Some file lawsuits hoping to get a quick settlement from the defendant. Others file frivolous lawsuits because they're trying to make a political point. Still others file frivolous lawsuits because they are mentally ill or have a personality disorder. These lawsuits have negative consequences. They waste the court's time and resources, making it difficult for people with legitimate claims to get their day in court. They can be used to harass or intimidate people, which can have a chilling effect on free speech and other essential rights. Several things can be done to combat frivolous lawsuits. One thing that can be done is to educate people about law, so they're less likely to file frivolous lawsuits. Another thing is requiring them to pay filing fee or provide evidence to support their claims before the case goes to trial. Investigations. Investigation ineffectiveness is failure of an investigation to gather or present sufficient evidence to support a finding of guilt or innocence. Investigation ineffectiveness can occur for a variety of reasons, including lack of resources, bias, misconduct, like tampering with evidence or falsifying reports, or incompetence. Investigations are often quite difficult processes. In fact, most cases are dropped after the first day of the follow-up investigation, or are investigated for a total of 4 hours or less. Early in an investigation, the focus is usually on the victim. Sometimes you have preliminary investigations by parole officers, which can be critical to determining whether a case can be built. Sentencing. The sentencing of criminals is a complex and controversial issue. Many factors must be considered when determining the appropriate punishment for a crime, including the severity of the offense, the offender's criminal history, and potential for rehabilitation. There are several goals that sentencing seeks to achieve. These include deterrence. This is to discourage people from committing crimes by making them aware of the potential consequences for their actions. Incapacitation. This goal is to prevent criminals from committing crimes further by removing them from society. Retribution, which aims to punish criminals for their crimes and satisfies the public's desire for justice. And rehabilitation, which is to help criminals overcome the factors that led them to commit the crimes and become more productive members of society. Types of sentences. There are a variety of different types of sentences that can be imposed on criminals. These include imprisonment, which is the most common form of punishment for serious crimes. The length of imprisonment can vary depending on the severity of the offense, the offender's criminal history, and the state's sentencing guidelines. Probation, which is a sentence that allows the offender to remain in the community while supervised by a probation officer. Probation may accompany other conditions, such as community service or drug treatment. Fines. These are monetary penalties that are imposed on offenders. The acceptable amount can vary based on the severity of the offense. Restitution. Restitution is a payment that is made by the offender to the victim of the crime. Restitution is typically based on the cost of the victim's losses. And other sentences can include community service, drug treatment, and mental health treatment. Sentencing factors. The following factors are typically considered when determining the appropriate sentence. The severity of the offense. Obviously, the more serious the offense, the more severe the sentence is likely to be. The offender's criminal history. An offender with a history of criminal activity is more likely to receive a harsher sentence than someone with no prior record. The offender's age and mental health. This could be relevant and considered. Certainly people that are children receive less harsh sentences, and people that are not considered fully mentally competent may not be considered fully responsible for their actions. And finally, the potential for rehabilitation. If there's an indication that this person can be rehabilitated, the sentence is likely to be less severe. A halfway house is a residential facility that supports and guides people transitioning from a more restrictive setting, such as a prison, a mental health institution, or a drug treatment program, to independent living in the community. Halfway houses are typically offer various services, such as counseling, job training, and life education skills. They also provide a safe and supportive environment where residents can learn to live independently and avoid relapse. Halfway houses are widely used as treatment models. The term halfway house is used because these facilities are seen as a step between the more structured environment of a residential treatment program and complete independence of living on one's own. Halfway houses can be a valuable resource for people trying to reintegrate into society after incarceration or treatment. They can support the guidance of people to transition to independent living. Juvenile offenders. Juvenile offenders are children that a judge finds to have committed a delinquent act. Juvenile offenders can be sentenced to various punishments, including probation, community service, restitution, and incarceration. The first step in juvenile justice is adjudication. If the judge finds that the juvenile has committed a delinquent act, they will be adjudicated delinquent. The judge will then determine the appropriate disposition, which the sentence that the juvenile will serve. Dispositions can vary based on the severity of the offense, the juvenile's criminal history, and the juvenile's age and maturity level. The sentences that can be imposed on juveniles do vary from state to state. Once the juvenile offender has been adjudicated and sentenced, the juvenile can be committed and placed in a correctional facility, usually one that is specified for juveniles. Juvenile justice aims to protect the public, rehabilitate the juveniles, and hold them accountable for their actions. The juvenile justice system is designed to be more rehabilitative than adult criminal justice systems. This is because children are still developing and more likely to be rehabilitated than adults. The future of juvenile justice is uncertain. There is a growing debate about whether juveniles should be treated more like adults or children. Some people believe that juveniles should be held accountable for their actions in the same way that adults are. Others believe that juveniles should be treated more leniently because they are still developing. Biochemical factors. Biochemical factors are biological processes that occur in the body. They can be influenced by genetics, environment, and lifestyle. Some biochemical factors have been linked to criminal behavior. Biochemical factors can play a role in criminal justice in several ways. First, they can be used to assess the risk of recidivism. People with specific biochemical profiles are more likely to reoffend. Second, biochemical factors can be used to develop treatment programs for offenders. Treatment programs that address biochemical factors can be more effective than traditional treatment programs. Third, biochemical factors can be used to help law enforcement identify and apprehend criminals. For example, police can use DNA evidence to identify criminals. Examples of biochemical factors include 1. Environmental constraints that limit or restrict an individual's behavior. For example, living in a high-crime neighborhood can be an environmental constraint that increases the risk of criminal behavior. Hypoglycemia is a condition in which the blood sugar level is too low. This can lead to symptoms such as shaking, sweating, and irritability. In some cases, hypoglycemia can lead to aggression and violence. Testosterone is a hormone that is produced by testes in males. It's also produced in smaller amounts by females. It has been linked to aggression and violence in both males and females. Hormonal changes can occur during times of stress or trauma. These changes can lead to irritability, aggression, and violence. The death penalty. The death penalty is currently legal in about half of United States states, as well as by the federal government and the military. However, several states have abolished the death penalty in recent years, and the number of executions in the United States has declined significantly since the 1990s. Several methods can carry out the death penalty, including lethal injection, electrocution, gas inhalation, firing squad, and hanging. The method of execution that is used varies from state to state, but lethal injection dominates in today's day and age. The death penalty is a controversial topic that has been debated for centuries. There are many arguments for and against the death penalty. It's a complex issue with no easy answers. One of the most controversial aspects of the death penalty is its use on juvenile offenders. In the United States, the death penalty was first used on a juvenile offender in 1642 when a 12-year-old boy was hanged for murder. The death penalty for juveniles was abolished in the United States in 1972 and reinstated in 1976. Finally, in 2005, in Roper v. Simmons, the Supreme Court ruled that the Eighth Amendment prohibits the death penalty for persons who committed their crimes when they were under 18 years of age. The Supreme Court used several arguments to make that decision. One argument is that juveniles are less responsible for their actions than adults. Their brains are not fully developed and they may not fully understand the consequences of their actions. Additionally, juveniles are more likely to be influenced by peer pressure and other factors that make them more likely to commit crimes. Arguments against the death penalty in general often center around the argument that it is cruel and unusual punishment. The death penalty is irreversible, and there have been cases where people have been executed and later found to be innocent. Suspended sentence. A suspended sentence, also known as a conditional sentence, is a type of criminal sentence that allows a convicted person to avoid serving time in prison. In exchange for the suspended sentence, the convicted person must agree to certain conditions like probation, community service, or drug treatment. If the convicted person violates the conditions, they may be ordered to serve the suspended sentence in prison. Suspended sentences are often used to rehabilitate offenders and keep them out of prison. They can also save the government money, as it's less expensive to supervise an offender on probation than to incarcerate them. For example, a sentence might be suspended if a dependent undergoes a period of community treatment. Rehabilitation. Rehabilitation is helping offenders change their behaviors so they're less likely to reoffend. It's a crucial goal of the criminal justice system and is seen as an alternative to punishment. Rehabilitation is a form of sentencing aimed at reducing the future criminality by treating and eliminating the underlying causes of crime. Rehabilitation is essential for several reasons. It can help reduce recidivism rates, which means the rate at which the offenders reoffend after being released from prison. Studies have shown that rehabilitation programs can reduce recidivism rates by up to 50%. Second, rehabilitation can help protect the public. By helping offenders change their behavior, rehabilitation can make it less likely that they will commit another crime. And finally, rehabilitation can help offenders become productive members of society. By providing them with the skills and knowledge they need to succeed, rehabilitation can help them to find jobs, support themselves, and contribute to their communities.